Hi. At Kingsley Napoli, we thought it might be interesting to do a short series of podcasts on issues which might be of interest to people who are running businesses outside the US and are looking to start operating in the US, particularly things that may be rather different from European or UK businesses. I'm delighted to be joined today by John Gilbert from Sandberg Phoenix in St. Louis, who is a labour law specialist. And in this context, labour law really refers to union law. And he's going to give us a quick heads up on some of the key issues that you might need to know from a labour law perspective if you're thinking about acquiring a US company or opening up your own branch in the US. John, thanks very much for making the time to speak to us about this.
Well, John, it's my pleasure. Thanks for the opportunity. As you may be aware, in the United States, we have a very strong labor union presence. And actually, one of the most fascinating things going on right now is a battle in the courts as to the constitutional legitimacy of the National Labor Relations Board, which has jurisdiction over private sector labor law. We have a district courts, which are the trial courts here, are disagreeing over whether the NLRB is properly authorized. And we have a split in the courts, which will now have to be resolved by the courts of appeals and eventually the U.S. Supreme Court. But in the meantime, in the federal districts in which the courts have held the NLRB was not properly authorized, everything is grind to a halt. So it's kind of an interesting phenomenon, and because of our federalism structure, we'll have some courts that aren't hearing these cases and won't let the NLRB act, and others that will. So that's going to be a really fascinating process and outcome that will eventually be resolved by the Supreme Court. But in the meantime, we're still dealing with labor law here. And as I indicated, in the United States, public sector labor relations is handled by the National Labor Relations Board. About 10 to 12% of the private workforce is organized. And even though that doesn't sound like very many, the unions in the United States are very powerful and have a lot of political clout, especially when the Democrats are in office. The largest number of unionized employees, of course, like in the UK, are public sector employees, and each state has its own labor relations board. So it's kind of complicated, but most of them follow National Labor Relations Act law. And the big challenge here is in terms of organization. The current National Labor Relations Board has made it so easy for unions to organize that we're focusing most of our attention now on avoiding what are called unfair labor practice charges. And those are generally refusing to bargain or treating a member of a collective bargaining unit inconsistent with the contract or the statute. And so there's a whole process for that. And the key to avoiding unfair labor practice charges, primarily in my practice, which I've been doing this now nearly 50 years, the key to avoiding these unfair labor practice charges is, as difficult as it is, treating your workforce, especially those who are organized, with dignity and respect, and maybe tolerating a few things you don't like to have in the workplace in order to have labor peace, because the unfair labor practice process is lengthy, complicated, expensive, and it's to be avoided if at all possible. The primary unfair labor practice charge that I see in my practice is a refusal to bargain in good faith. And when you get into a contest over that, it's miserable. So one of the major goals I have as a labor lawyer for management is to avoid unfair labor practice charges. Another important aspect of our system are what are called subjects of bargaining. So when a union achieves certification by the NLRB, the employer and the union then have a mutual duty to bargain in good faith. Many clients are surprised to learn that there's no obligation to agree. The obligation is to bargain in good faith. So that leads to negotiations over what we call mandatory subjects of bargaining, which are anything that has to do with hours, wages, and terms and conditions of employment, which leaves very little to what we call permissive bargaining subjects, which are those that we're not legally required to bargain over, but often do. And so there's general, the NLRB has a general set of rules about what's mandatory and what's permissive. But the key in the duty to bargain is that, again, you don't have to agree, but you have to come to the table, bargain in good faith, exchange proposals, and avoid something called surface bargaining, which the unions frequently allege when they can't reach an agreement at the table because management is holding firm on its positions. And surface bargaining is where you're just there, you make it look like you're bargaining, but you really have no intention of bargaining in good faith. Very few, in my practice, very few employers engage in surface bargaining. We try to get a deal done. Sometimes you can't, and sometimes you'll bargain through the period where you're required to bargain, which is 1 year after certification of the union. And then, if you don't reach an agreement, your duty to bargain expires. So it's challenging sometimes. And of course, in this duty to bargain that I've talked about, again, you have to bargain in good faith. And sometimes when the negotiations break down, or you actually have one or the other side not negotiating in good faith, we have the big issue of strikes. In fact, we have Canada right now is undergoing a strike that's going to have a huge impact on Canada and the United States. It's a rail strike. And those things are tremendously disruptive to national economies. So when there's a strike, of course, the union bargaining unit members go out on strike. They don't work. And the employer also has a concomitant option of locking out striking employees, which I don't really recommend. It's very bad optics and creates tremendous animosity for when the strike is over and you try to reach a strike settlement agreement. But on the striking, when the union strikes, the employer here has the option of hiring strike replacements. And if the strike is what we call an economic strike, we can hire permanent replacements. If it's a strike over unfair labor practices, then you can hire temporary replacements. And that's the method by which employers can survive a strike. But nobody wants one. The unions don't, the employers don't, but it happens on occasion. So that's sort of a quick review of how labor law works here in the United States. And it's always challenging. It's ever changing because one of the problems we run into is every time a new president is elected, if they're from a different party and they appoint members of the National Labor Relations Board, the law changes. And when President Bush II was in office, his board had more conservative policies and cases. When President Obama was elected, everything moved significantly to the left. Then you have Trump come in, and of course, there's a huge move to the right. Then when Biden was elected, they moved back to the Obama era stuff, and it drives us labor lawyers crazy. And now if Trump gets elected in the fall, it's going to go to the right again, and we're going to go back and it really makes it hard for employers to plan and to negotiate and to know what the cases are going to require. So we're constantly in a state of flux here when it comes to private sector labor law.
That's really interesting. Can I ask a couple of questions, which I think might be useful for listeners? One is on the subject of mandatory bargaining, which you said was things about kind of remuneration and terms and conditions of employment, that kind of thing. How granular does that get? I mean, does it get down to kind of length of tea breaks and bits of equipment, or is it kind of more high level?
No, that's a great question. It does get down to the level of breaks, and as depending upon who's in office, the expansion or contraction takes place. But yes, it gets down to minutia, scheduling, time off, pension plans. I mean, it gets down to the granular level, definitely.
And if something changes in the business, you come to your agreement in your first year after the union is appointed, say, and you come to your agreement, and then things change in the business, they change in the wider economy. How easy is it to go back and have another, presumably good faith negotiation as to changes to the bargain?
That's a great question. And that happens a lot, because especially when the economy changes, and as you know, business is dynamic. And so there are methods by which that can be done. The union will come to management and ask for midterm bargaining, we call it, because most collective bargaining agreements are for 3 years. There's been a trend to go longer, but 3 years is the norm. And so if there is midterm bargaining, either party can request midterm bargaining. And so the employer can do it, the union can do it, unless there is something in the agreement which we call a zipper clause. And a zipper clause, which I'm hot and cold on these, but it's a clause at the end of the agreement that says no more bargaining about anything for the term of the agreement. And I don't like them because it takes away flexibility. A lot of employers like them because then it makes everything certain, and they have certainty and dependability for the 3 years. But even with a zipper clause, either party can say, well, let's reopen, and they can do it. And generally, in my practice anyhow, I've never really had an employer or a union say no, because by the time you get to midterm bargaining, somebody wants something different. So you have trade-offs. So, you can say to a union, hey, let's go back to the table on increases. And they'll say, oh, okay, that's fine, as long as we can talk about benefits again. And so there is a method by which that's done, and it's frequent. It does happen frequently. It's a great question.
Okay, good to know there's at least a bit of flexibility there, and you're not permanently locked in. In the UK, we have issues with old pieces of union bargaining, which you can just never get rid of. One that's been mentioned a lot in the press recently is on our railways. You mentioned rail strikes earlier. Apparently, if a manager talks to an employee during an employee break period, the employee is permitted to restart the break. So they can be 50 minutes into their lunch hour, and if a manager says hi, in theory, they can go back to the start, which is a bit crazy in my book.
Yes, I agreed.
One last question. The duty of good faith and demonstrating that you're negotiating in good faith. Presumably, it's important to articulate kind of in the background the reasons why you're asking for what you're asking for. Is that the kind of thing you do with your clients to help them, explain the specifics of why they're saying yes and no to particular proposals, so there's a record?
Absolutely. And what we normally do, because in order to establish good faith bargaining, if it's challenged by the union, is you have to show you've made proposals, that there's a rationale behind those proposals, and that this is how your position on those proposals. And there's a concept, when I talked about surface bargaining, there's another concept called hard bargaining, where you make your proposal, or you answer the union's proposal, you explain the rationale, you make sure it's recorded in bargaining minutes, and then you say, we're not changing, and here's why. And that type of bargaining is permissible, but you have to have a good record, because if they challenge you, the first thing the labor board asks for are the bargaining notes that explain all of this. And so detailed bargaining notes really help here, because of this concept of hard bargaining. And if you have an acceptable business rationale for hard bargaining, the NLRB will recognize that.
That's great, John. That's really interesting. Thank you. And I'm sure that will be really useful for anybody who's thinking about opening a business or hiring people in the US. Obviously, anybody who's listening, if you are thinking about doing that, then John and his colleagues at Sandberg Phoenix will be able to help you with all of the elements of opening a business, from labour law through more conventional employment law, employment contracts, premises, all of that good stuff. So please do get in touch with them, or get in touch with us and we can put you in contact with them. John, thanks again for taking the time to speak to me. Really appreciated it. It's a really interesting conversation. Thank you.
Well, John, thanks for the opportunity. I appreciate it. And I hope that our viewers and listeners will benefit from it. Thank you.
Sure. Thanks.